Hello and welcome to the PrePass webinar, The Benefits of Truck Crash Preventability Programs. I'm Evan Lockridge, your host and Content Marketing Manager for PrePass Safety Alliance. PrePass Safety Alliance is the provider of PrePass way station bypass and toll payment services, as well as data dashboard tools for improving safety, efficiency, and cost control. Today we'll be looking at the Federal Motor Carrier Safety Administration's Crash Preventability Determination Program, how it can help you, and how you can set up such a program with your trucking operation. Before we get started, you should know that we have muted all lines, so if you have a question, type it into the questions box located in the webinar panel. We will answer your questions at the end of the presentation. This webinar is being recorded and all attendees should receive access to it within 24 hours. Also, at the end of the webinar, you'll receive a quick survey, so please take a few moments to provide your feedback. If you experience technical problems with either hearing or seeing the webinar, call 800-514-1317 for technical support. That's 1-800-514-1317. At this time, I'd like to welcome our speakers, Sean Garney and Steve Keppler, co-directors at Scopelitis Transportation Consulting. Sean began his career in trucking nearly 20 years ago. Prior to his current job, he worked for the contractor that operates FMCSA's pre-employment screening program and was director of safety policy at the American Trucking Associations. Steve Keppler has nearly 30 years of transportation experience, beginning in the field as an investigator and inspector for the U.S. DOT. Prior to joining Scopelitis, he was executive director of the Commercial Vehicle Safety Alliance and was also with the Intermodal Association of North America. Now, at this time, I'll turn the presentation over to them, beginning with Sean Garney.
Thanks, Evan. Really appreciate you guys having us on today. Super excited to share with you and your attendees a little bit more about crash preventability programs. Here's a brief look at our agenda. You know, I really believe when we're talking about any new programs, it's important to first investigate sort of from whence it came, give you a little bit of the history of crash preventability in general, how it exists in the government space, how it existed previously, and sort of where it sits with motor carriers today. From there, we'll go sort of more into a detailed dive of what's actually in the FMCSA's crash preventability program. I'll hand it over to my partner, Steve, for that. And just as a heads up to those of you attending, the format's going to be a little bit different maybe than you're used to seeing with traditional webinars. We've sort of planned pause points and break points in our presentation to hopefully have a little bit of a conversation with y'all. So if you have any questions, don't forget you got your question panel there on the left-hand side or the bottom side or wherever you've organized it. You can pop in your questions, and we'll have a number of planned pauses, like I said, that you guys can, that everybody participating can jump in and start to ask their questions. So without further ado, let's jump into that history section that I talked about before. And I'm gonna, you know, if I was in person, I'd have folks raise their hand to see who remembers what Part 394 is in the federal regulations. And I'd be curious to know how many of you really do. Of course, probably everybody on the call is familiar with Part 395. That's our wonderful hours of service rules. Part 393 talks about parts and accessories of vehicles. But what the heck is 394? Well, if you open up your book today and go to page whatever where 394 is, you'll see that it's actually reserved for future use. But in the past, in the 80s and the 90s and before, 394 was for the notification and reporting of accidents. And so carriers were required to report all of the accidents that they had to the Federal Highway Administration's Regional Office of Motor Carrier Safety. And, you know, they had to record reportable accidents, which we all know what the definition of a reportable accident is today. It's an accident in which there was a fatality, an injury, or a tow away or a disabling damage that required a tow from the scene. But, you know, back when 394 was part of our rules, it was actually a fatality, an injury, or property damage of more than $4,000. And if you had incurred one of these crashes, you'd have to report within 15 days, like I said, to the Federal Highway Administration's Office of Motor Carrier Safety. This sort of dates the program, of course, because the Office of Motor Carrier Safety is the predecessor to FMCSA. You'd have to report this information within 15 days, and you'd have to use this MCS 50 form, which was a pretty detailed form with 26 data elements. And the idea was to help safety investigators and motor carriers gather enough information to sort of help them get at a little bit about the causal factors or the potentially the preventability of such crashes. Now, of course, if you had a fatal crash, you had to upload this information within 24 hours, and you had to do so by telegraph or telephone. I'm not sure the last time I tried to submit something to the government by telegraph, but certainly this puts a date on it. Now, maybe should have had my partner Steve do this portion of the presentation, because in speaking to him prior to this presentation, and as you heard from Steve's bio, he used to do these types of audits on motor carriers. One of the first things that an auditor would do when they came in is they'd come in and they'd ask for all your MCS 50 files. And they'd want to look at those files and try to get at a little bit more about preventability, right? They'd want to know what the circumstances of these accidents were and whether or not the motor carrier could have prevented them. And they abided by fairly strict definitions of a preventable or not preventable accident. At the time, a preventable accident was one that involved a commercial motor vehicle that could have been averted, but for the act or failure to act by the motor carrier or the driver. And it's this phrase, or failure to act, which really raises that bar, right? Which makes it a lot more difficult to have a crash be considered not preventable, because it's incumbent upon the driver to anticipate the actions of other drivers on the road and take action to actively avoid that crash. And so the bar was pretty high for them. Now, of course, there's still a definition for those trivia buffs. Of course, there's still a definition of a preventable accident. It lives in Part 385 today. That's the part of the rules that sort of dictates how federal and state MCSAP agency officials need to review motor carriers to provide safety ratings and that sort of thing. Now, FMCSA still does conduct these preventability assessments, but no longer do they sort of do them writ large. Instead, if a state or federal official comes in and reviews your operation, they're going to calculate a crash rate, right? And if that crash rate is above 1.5 or 1.7 crashes per million miles, depending on the type of operation that you have, then you would automatically be given an unsatisfactory rating in that particular factor, in that crash factor. Now, if you're unsatisfied with that, you can ask an enforcement official to go back and to look at your crashes and to make a preventability determination. And if crashes are deemed non-preventable, then they're removed from the calculation of this crash factor. In those cases, that Part 395 definition is as follows. If a driver who exercised normal judgment and foresight could have foreseen the possibility of an accident that in fact occurred and avoided it by taking steps within his or her control, which would not have caused risk of another kind of mishap, then that accident was preventable. So again, we're getting at this sort of defensive driving concept, which really looks to whether or not the driver anticipated hazards and could have prevented them. As you see here on the bottom of your slide, the Part 394 was eliminated in 1993, but I think carriers still find value in collecting this additional type of data and using it in their internal operations. And a lot of carriers have built on this type of data or this sort of accident investigation protocol to build their own sort of carrier-based preventability programs. These are widely used among fleet operators. Of course, not all operators have them, and there's a lot of good reasons, a lot of bad and some bad reasons for using them. But generally, I think it's widely used among fleet operators because they feel that it really helps them measure their program effectiveness in a real way, right? It provides additional granular look into your crash data. So an insurance company will tell you that any crash today raises the likelihood of your involvement into a future crash tomorrow. But that's less helpful if you're trying to look into why crashes are happening and prevent them in the future, right? So it gives you additional insight into your crash scenarios, right? you can create rates for all crashes or limit them to just DOT crashes. You can look at preventable versus non-preventable crashes. And so that data is important. It can also create a very equitable basis for safety incentive programs. Probably a lot of the carriers on the call right now have safety incentive programs, which say things like, if my driver has, can go a whole year without an accident, or can go 1,000,000 miles without an accident, well, they'll be incentivized by X, Y, or Z, whether it's a financial reward or some kind of swag or some sort of thing. But having a preventability portion to that program creates a little bit more equitability. And I say that to mean it's a hard job out there. Truck drivers have a lot to think about and a lot to be concerned about, especially when trying to anticipate the erratic actions of drivers like Steve Keppler, who's out there running into anything that moves and some things that don't move. No, I'm just kidding, Steve. Steve's a great driver for everybody on the webinar, in case you're keeping score. But in any event, it allows for you to provide some accommodation to these drivers who are involved in circumstances that they simply could not have prevented, right? And allows them to stay in the safety incentive program, to continue to be incentivized by that program to drive safer every day. It also communicates a higher standard, right? And this is really based on the various definitions that folks use for these programs. We already talked about the definitions used by the federal government to determine preventability, and there's lots of other organizations that have developed definitions for preventability that communicate this higher standard, that really raise the bar for what should be considered preventable or non-preventable. And I'll give you a couple quick examples here. The first is the National Safety Council, and I think everybody's probably familiar with this organization, and they've defined a preventable accident as one in which the driver failed to do everything which he or she could have done to avoid it. So this is a pretty basic definition, but it really gets at drivers working hard to avoid potential crashes. There's, of course, the American Trucking Association that has also published a definition of preventability or preventable accidents. Of course, they've published a whole bunch of definitions over the years with a sharper and sharper focus on legal liability. Their most recent definition is more of a question, right? It asks, was the vehicle driven in such a way to make due allowances for the conditions of the road, weather, and traffic, and also ensure the mistakes of other drivers didn't involve the driver in the collision? And so by developing a program like Preventability, you're clearly communicating to your driver that, hey, we're not holding you to a standard of fault. We're holding you to a higher standard of care that you as a professional driver should be held to, because you're out there presumably better than the casual driver, certainly better than Steve Keppler drives. And it also reinforces company policies. So if you have various company policies about ways that drivers should behave on the road, typically in most preventability programs, if a driver violates that company policy, then that while driving, then that crash is automatically preventable. And so you're reinforcing your company policies there. And again, serves as a strong basis for a thorough investigation of crashes. So what does that look like? How do these programs work? I'll say that, first of all, motor carriers will clearly outline the eligibility parameters of the program, right? And they'll provide probably a more expansive definition of an accident, right? Because there are incidents on the roads that don't require a tow that for the sake of insurance or the carrier should be considered an accident. So it's going to encompass more things. Sometimes there's a dollar amount on the impact of the crash that's important. And they typically involve some company policy exclusion. Again, like I said, if the driver's violating the company policy, then that is a preventable crash, but also usually contains some very clear exclusions, some types of crashes or scenarios that might meet the definition of a crash under the program, but should be excluded. For instance, normal wear and tear of a vehicle, If there was actually no damage or injury, maybe it meets the definition, there was contact but no damage. If the vehicle is properly parked in a legal parking spot and the driver could have done nothing to avoid it, oftentimes those types of crashes are excluded. So, so the first thing that they do, of course, is establish these clear parameters and then begin establishing protocols that they use to investigate those crashes. Most typically, and not always, but most typically, the first or preliminary decision on the preventability of a crash is made by a motor carrier safety personnel, whether it's a regional manager or the safety director, and it's incumbent on that person to investigate the crash in a thorough manner, to look at the driver report, the report that the driver likely submitted to the crash, the police accident report, insurance report, or any other internal documents that they have, and then make what is at least a preliminary determination. And I think most folks who have these programs find that most carriers don't dispute those initial determinations because they understand the standard of care to which they're held, but occasionally they do. And it's important to have a process in place that allows drivers to appeal these particular decisions, right? And that's where this crash review committee comes in. Typically, a company would have a crash review committee. I've seen all sizes of committees, but 3 to 5 is usually about the size of the committee. Obviously, it's always an odd number because we don't like ties in committees. And it generally has representatives from management and, of course, from the driver pool too. And this is really important to have a driver involved in this particular committee because, it lends some credibility and some finality to the decision of this committee, and decisions here are typically final. And I think carriers that invoke these programs really feel that they provide a lot of additional value to safety personnel as they continue to investigate these accidents, to drivers who feel like they have a role in the investigation of these accidents, and of course to the information that they provide you as far as highlighting what may be some positive countermeasures that you can provide to the driver to avoid these types of accidents in the future. So I guess with that, I could say a lot more about it, but I'd probably bore everybody on the call. So I'll kick it back over to Evan to see if he happens to have any questions for us at all. Evan?
Yeah, thank you very much. Very informative there. And I want to remind people that for their questions, go ahead and start typing them into the questions panel, and we'll get to your questions at the end of the presentation. But a couple I wanted to throw at you right here. First one being, what are the risks to having an internal crash preventability program?
Yeah, thanks, Evan. I think I had a slide which conveniently talked about all the great benefits of a program like this, and of course, if it was all benefits, then every carrier everywhere would have a program like this, right? So there are risks associated with the programs. The most commonly cited risk is this idea of legal liability, and that's not an unfounded risk. Companies that have made preventability determinations, first things first, it's important for them to couch these programs and these determinations in an opportunity for remedial action. So if you're going to set up a program like this, make sure that it's clear to everybody that we're not looking at fault. We're not trying to get at fault. What we're trying to get at is, where's my coachable moment? What's the remedial action that this might provide? Now, determinations of these programs, are often discoverable in the event of post-crash litigation, and sometimes admissible as well. I mean, legal defense lawyers have mechanisms they can use to try to keep it out of the courtroom, but it's possible that it could make it in. There's some mitigating factors that carriers can do, such as not making the determination right away in the event of a crash they think might go there. But then, with all of this liability concern, when you ask folks, well, why do carriers do it? I think they all say it's because of the huge benefits, not to mention the fact that 95% of cases settle before they go to court. So this 95 to 5 ratio looks pretty beneficial given the future crash reduction and safety culture benefits of such programs. So there's a long answer to a short question. I hope it was helpful.
Was one other question for you before we get back to presentation. You were talking about setting up a committee just a moment ago. Does having an internal program require having a committee? I mean, couldn't just the safety director just make the final decision, for instance?
Oh, absolutely. And that happens for sure. I think depending on the size of the carrier and, the bandwidth for such a thing, it might make sense to just have it set with the safety director. Now, if that's the case in your fleet, I certainly would strongly recommend having some sort of appeals process or some one-on-one conversation with the driver about whether or not it was preventable or it was not. When I work with carriers, I try to encourage this committee viewpoint because safety culture is super important to me, and having the driver have sort of some skin in the game, I think is important, and I think that's the benefit of that. But absolutely, I've seen that where it's just a single person who makes these determinations and then works out the results with the driver. So that's a great question.
All right, well, that's good. Well, let's get back to your presentation.
All right, I think with that, I'll kick it over to Steve, best driver in the room. Here you go, Steve.
Well, thanks, Sean. I appreciate that. My reputation precedes me. That last question, I think I'd just add a couple things, on the committee front. Certainly, one of the values of getting multiple people involved is you get different perspectives to the table for making those assessments and evaluations. And also you get buy-in from, depending on how you set it up, different elements of the organization, right? Oftentimes safety can be pigeonholed, if you will, into one department, but I think safety is everyone's responsibility. So I think, having those other perspectives can certainly help, the company and that safety culture Sean talked about. And I think before I get into here, Sean mentioned the whole 394 thing, and those crash as the MCS 50s. And that was there before CSA. We didn't have data back then the way we do now. And so we weren't able to select drivers and vehicles to target for investigations. So we had to make those preventability determinations on the front end of the process to decide how we wanted to further the investigation. And so we've come a long way since that time. We've got all these data tools and solutions and that are there to help us in that process, not just the investigators, but also the carriers, as all of you know. So with respect to the FMCSA's program, just a point before I jump in here, and I think I appreciate PrePass bringing this to the fore, because there's a big gap of carriers that have chosen to participate in this program. So far to date, there's only been 4,000 carriers that have used it out of a population of about 560,000. And so that's a big gap, and raising awareness to the importance of this program and having people take advantage of it is really important. And we appreciate PrePass bringing this to the community. So really, the program was really born of when CSA was launched and criticisms of CSA. And because the data was more open and public, it just wasn't available to investigators or the carrier or the insurer. But it's more open to the public, shippers and insurers and banks and everyone and their mother, if you will. We're looking at the data and using it to make safety-based decisions. And really, the industry came forward and said, look, if you're going to make this data public, we feel that some of these crashes aren't really our responsibility. And we think there needs to be a fairer process and more open, transparent process, if you will, to challenge those that we didn't think our driver was at fault. And they felt that it might not be appropriate for others to be judging my safety posture. And so Congress and FMCSA listened to that and took action. I will say that initially, when this was suggested, FMCSA initially pushed back and said they wanted to study it. They were concerned about what it would take to review every crash, being very resource intensive. They had estimated it would cost upwards of $11 million and take 2 years to adjudicate these crashes. And that was one of their big pushbacks. At the end of the day, there was a lot of conversation, and the industry came forward and said, okay, we understand where you're coming from. We'll suggest a list of crashes that we think are more obvious and can more clearly be determined to be not preventable, and really came forward with a more focused list. And things, for example, like an animal strike, running over a deer, as an example. So at the end of that, there was a compromise solution to look at certain crashes, the obvious ones, and really focusing on, okay, the preponderance of the evidence. So that led to a demonstration program that started in July 2017. And I won't go through the details of that other than to say it was a successful demonstration program. A big part of that was understanding the process, the feasibility for FMCSA to go through, and their contract support to evaluate this. And in the demonstration program, 96% of the crashes were deemed to be not preventable. Successful program. So in 2019, FMCSA came forward and said, okay, here's what we learned in the demonstration program. Here's how we're proposing to make edits. They took comments from the industry and really moved that into a permanent program, and took those suggestions and those comments in that program. They took some industry suggestions from the list in terms of the crash list, but they also added some more some crash scenarios and results that they from the demonstration program that may have been deemed ineligible during the demo program. So ultimately, what is it? It's a voluntary program, and ultimately the basic idea is giving carriers the opportunity to improve their scores by contesting preventable crashes and helping the agency consider not preventable determinations. Since CSA is relative, assuming that you're challenging these and getting those not preventable determinations, it can improve your scores against your peers. And so that's an important factor of the program, a big part of it, obviously. The way it works at a basic level is those not preventable determinations, the crashes do stay on the carrier profile, but the crash is removed from the calculation of the crash indicator basic in CSA. Another benefit is drivers can see their crashes on their own records through the PSP program, and they can also contest and correct them. And carriers can use this as a real selling point to drivers from a recruitment and retention standpoint, in that they're willing to go to bat for their drivers and contest some of these preventable crashes. So Sean talked about, from a definitional perspective, what the definition of preventable is. I think one thing I'll add to that is even if the driver was operating legally and was fulfilling the requirements of the crashes that are in the program, if for some reason the post-crash inspection report, for an example, showed an out-of-service violation or the driver was non-compliant at the time of that crash, what would normally be a not preventable crash would be deemed preventable. The not preventable determination really is a driver who exercises normal judgment and foresight could not have foreseen the possibility of an accident that in fact occurred and could not have avoided it by taking steps within his or her control. So the other classification from a definitional perspective is undecided. And what that essentially means is that the documentation submitted didn't allow for conclusive decision by reviewers, and this also includes cases that are closed because not enough information was requested. So there's definitions you'll see later as we show in the data how those play out. And from a functional perspective, I suspect most of the carriers, hopefully all on the line, are familiar with the data queues process, but that's the same process used for the preventability determination program. So you use the data queue submission, you submit RDRs, include a police action report as evidence that it's not preventable. For those that are fatals, you're required to submit drug and alcohol test results, and you can include other suggested documentation, videos, pictures, court documents. Important that your submission, you provide substantive data to your challenge. John? So a quick run through of the crashes that are accepted as part of the program. There's 12 essential categories: struck in the rear, and it is what you would think it would be, struck in the rear. Also struck on side at the rear, which is a newer part of the definition, which is one of the recent changes. And this would mean, you know, the vehicle has to be traveling behind the CMV prior to striking the vehicle. And I'll note here too that if you're not aware of FMCSA's Preventability guide, I would strongly encourage you to get a copy of it and understand the guide. Is a lot of more detailed information than I'm certainly going to go over here. Wrong direction or illegal turns is a crash when the CMV was struck by a motorist driving in the wrong direction or by another motorist operating in the wrong direction, or a vehicle that was making a U-turn or illegal turn. This is a new portion of this definition. The thing I'll note here is a higher percentage of these are ineligible, and really because the vehicle must be completely on their side of the highway. It can't be at all encroaching on the center line to meet the eligibility requirements for this particular crash. Parked or legally stopped is when a CMV is struck when they're legally stopped at a traffic control device, stop sign, red light, yield sign, or while parked, including while the vehicle was unattended. Failure of other vehicle to stop is really when the truck was struck by a vehicle that did not stop or slow in traffic, or by a vehicle that failed to stop at a traffic control device. Suicide is, that's clear there. But I think the important thing I'll note about that is you need documentation as part of the investigation, the police action report, that it was of the intent to meet the eligibility requirements for that particular crash type. Under the influence is either by an individual or another motorist. Again, I'll mention here, and this is not just under the influence, but also obviously operating while intoxicated. And it's based on the legal standard of the jurisdiction where the crash occurred. And again, what's important here is documentation of this needs to be also recorded on the police action report, of field sobriety exam, or some other documentation that was contributory to the crash or was evident at the time of the crash. Medical issues, falling asleep, distracted driving. These were added. They're new and really aligning with DOT's goals. Really distracted driving being an issue, and medical related issues. Whether a driver experienced a medical issue that contributed to the crash, or they fell asleep or admitted to distracted driving, and that's not just texting, cell phone, but also passengers, other distractions. And again, this needs to be documented on the police action report to meet the eligibility requirement. Cargo, equipment, debris, infrastructure, and it is exactly what it is. You know, something falling in front of the vehicle or identifiable items in the roadway, and the crash was a result of that particular failure. And the driver should not have been there if they were, for example, if they had an hours of service violation at the time of that crash, that would deem to be ineligible because they should not have been there at that time because they're in violation, as an example. Animal strike is what it says. And again, the situation there is if the driver should not have been there, it's not eligible. Again, if there was a particular violation at the time of the crash. Rare and unusual the question answers the question. Well, the question is, did that really happen? And certainly there are circumstances where this situation has occurred. Airplanes landing on the highway, as an example, and this is a catch-all for many submissions. It's the proverbial kitchen sink, if you will. And as a result, the success rate isn't necessarily as high when challenging these types of crashes. So a few notes on examples of some of the new crashes types that have been added. Struck in the side at the rear. I think a couple points here. The vehicle's got to be in the same direction of travel. The examples here are merging and also crossing a dotted line. Situations where the truck driver can't necessarily anticipate the speed of the other vehicle. Important point here is these crash types need to be at the 5 and 7 o'clock angles, if you will. Other angles like 6 or 9 would not be eligible. And again, important, it has to be in the same direction of travel. Legal turns. I think an important thing that was added here is they added the squeeze play, which is something that the industry has been championing for a while. As we know, drivers are trained to make wide right turns, and too many aggressive drivers don't understand the operations of a commercial vehicle, and they try and squeeze in. And this one has to be in association with a traffic control device situation. If not, it's ineligible, and also includes U-turns. A failure to stop, again, it has to be in association with a traffic control device. Also includes vehicles that are slowed or stopped in traffic and are struck from behind. Prior to this new change, it was only vehicles that were properly stopped or legally parked. So again, this is a circumstance that was added. These scenarios happen relatively frequently, so that was a good addition by the agency. Multiple vehicle crashes, they're not necessarily an official category, but they are added as an addition to other categories. So a number of situations where this occurs, and where cars are striking multiple cars, moving in the wrong direction. Again, it gets back to that same situation. First of all, the first vehicle performing action is determining the eligibility of that, whether that crash is acceptable or not. And again, it has to be the vehicle is not on or encroaching on the center line. A few more parked or legally stopped. They added multiple vehicle crashes and examples to this situation. It includes vehicles that are stopped in the usual course of business, and things like garbage trucks, utility vehicles. These were previously not included in the crash scenarios. Only legally stopped or parked were permitted, but this is an add, new crash types that were added. Urban delivery vehicles also, as an example. They added multiple vehicle crashes and types here to this particular definition. Medical issues and falling asleep. Again, I think that the thing that I'll reference here and make sure that we emphasize, documentation of the issue has to be included, whether it's a citation or the police action report. Again, not eligible otherwise. And rare, unusual, and here are the examples. And the agency actually put this in the Federal Register when they put it out, because these things actually happened. But again, I'll mention this is becoming, this is kind of the catch-all section, and a lot of the where there is, eligibility determinations that are being not being successful. This is one of the categories where that's the case. So a few points on ineligible crash types. Again, we've talked about some of this already. Again, struck in the side of the rear if it's not at the 5 o'clock or 7 o'clock. Now, if there's another strike angle, 6, 9, or 3 as an example, it could be eligible for another crash type, but not for this particular crash type. Wrong direction, I already talked about that the vehicle can't be over the center line. If it is, then that's an issue. And also, the CMV driver may have been able to respond to the situation, which could create this ineligibility determination. And a couple things here, I'll mention it overall, and to make clear that the driver may not be at fault in a court of law, but for the purposes of the crash preventability determination, it may be preventable. And that's something to keep in mind, that's important going forward. FMCSA does not want to weigh into gray areas, which is why some of the clarity, and they want to be clear, they want to be take the crashes that are most obvious, that are important as part of this program. Under failure to stop, again, at an uncontrolled intersection where there's no traffic control device, these would be ineligible. The CMV driver could have seen or anticipated. Difficult to win these. Legal turns, again, if there's no traffic control device, even if the car was an idiot, for an example, and they had a green light and turned, but misjudged the turn and hit the back of the CMV, it still would not be deemed eligible. And back to the animal strike issue, because again, that is something that is more frequent than people would think. An ineligible one would be in the event that the driver attempted to avoid the animal and crashed into another object or ran off the road. That would be ineligible. So Evan, I think it probably took a little bit longer, but I think it's important to try and provide some descriptions to folks about the different elements of the program and the crash types. So I think we'll turn it back to you to see if there's any questions you want to throw out.
Yeah, a couple come to mind. I guess what are the main ways that FMCSA's preventability program and internal programs are different?
Well, I think, Sean outlined some of the differences with the carrier programs. Obviously, there's different incentives with the carrier programs and punitive measures than FMCSA. Obviously, the carrier programs are focused on company policy. They can be more expansive. In FMCSA, clearly the incentive is relating to CSA and your scores. So I think that's one difference. A number of carrier-based programs are broader. As we know, there's a lot more crash scenarios than occur within the determination program. In FMCSA, I think we've mentioned a couple times, they want to stay focused on clear and obvious crashes. They don't want to get into the gray. And a lot of crashes, as we know, are gray in many cases. So they wanted to steer clear of some of those the best they can, based, and because part of it is it's an administrative issue for them and resource intensive. And they wanted to focus on those crashes where they typically have good data from the police accident reports and they have clarity on the issue. Ultimately, they don't want to be the arbiter of truth, and they really want to try and focus on those things that are agreeable and they can get off the carrier's record quickly.
Now, in your presentation, you talked about some new scenarios that had been added. Is there a possibility that more new scenarios will be added to the FMCSA program down the road? And are there efforts underway to expand or improve the determination program?
Well, I think that's a good question. I the agency, if you speak with them, they'll tell you that from their perspective, it's very successful. They have expanded it once already. So history is on our side that they have done it in the past. I think it's certainly possible, but I think what we found is as more scenarios are considered, it gets a little more murky on clarity and resolution and the time it takes to resolve some of these determinations. And the law of diminishing returns kicks in. But I will say they have several. They're monitoring on a regular basis. They've got a couple of research projects underway right now where they're looking at it. For example, they've got a research project looking at artificial intelligence that can read the police action reports and making determinations on simple crashes. So it can make that process more efficient. They're also doing some additional research on the process itself of the program and seeing if there's ways where they can be more efficient. And I think they understand how important this program is to the industry and to ultimately to safety. So it's a high priority for them. And I think as they learn and get more experience, changes could happen. I think the challenge that I think they're balancing and will continue to have to balance is the resources to administer the program, because it is intensive, and obviously they have a lot of other priorities for how they're spending their money to do the mission of the agency. So that's something else that could impact it.
Okay, well, I want to thank both you and Sean for the presentation. Now, in just a moment, I want to get into the audience questions. So, audience, if you have a question, type it in the questions box located in the webinar panel. Now, if we do not get to all of your questions, we will respond to you directly with the email you provided at registration. Before we get to your questions, this brief message. PrePass is the leading way station bypass and toll payment platform in North America. The service allows qualified carriers to bypass way stations at highway speeds and also provides driver safety alerts, electronic toll payments, and informed safety and tolling software. More than 700,000 commercial vehicles from more than 77,000 fleets utilize PrePass. More information online at prepass.com. All right, let's get to some audience questions, Sean and Steve. And you were most recently talking about the FMCSA crash preventability program. I want to go back to that. Why did FMCSA only choose to allow certain types of crashes to be contested?
Yeah, I'll jump in here, Steve, I guess, and because I was pretty close to the issue at the time, and if I miss anything, please jump in here. But I can remember as an advocate for the American Trucking Associations when CSA was just rolling out that one of the very earliest criticisms of the program was that if my business partners, right, here we're talking about shippers, brokers, banks, if these folks are using CSA scores, CSA basic scores, including the crash indicator score, which while not publicly available was being requested by our business partners, if they're using this information to make safety-based business decisions, well, then perhaps it's inappropriate for them to make these business decisions based on crashes that my driver could not have prevented. And that was an argument that industry made early on. And surprisingly, it was an argument that FMCSA failed to mitigate or to counteract for an awful long time. And by taking that arrow out of our quiver, our advocacy on CSA would have been much less effective. But in any event, eventually, industry went to Congress and said, hey, this is a problem. And Congress told FMCSA, you better look into this. That leads to the study that Steve talked about, in which FMCSA said, hey, really, guys, we'd love to do this, but it's going to take us 2 years per crash and cost us $11 million. And so we're not super excited to get this done. And that's the point at which, the American Trucking Associations, myself, and our industry partners, went to FMCSA with a new idea. And we said, hey, what if we start by crashes that we can all sit around a table, look each other in the eyes and say, obviously these things are not preventable. And so we developed a short list of crashes. I think there were 8 or 9. These are crashes that we refer to as plainly evident. Shout out to Rob Abbott for coming up with that very technical term, that were plainly evident that our drivers, the driver of the commercial motor vehicle, could not have prevented it. And so that's sort of where that started, to narrow it down to just specific crashes. And that made FMCSA happy because, as Steve said, they don't want to be the arbiters of truth. They just want to help make basic determinations. So I hope that answered your question. And if it didn't, I'll kick it over to Steve to answer it.
Steve, anything you want to add?
No, I think he covered a lot of it. I think the other part of this is they wanted to exclude things that were not indicative of safety, a safety problem or driver error, and to look at it as a more a fair and equitable approach, and focusing on those things that everyone relatively or agreed with. And the data shows in the program, 97% of the submissions, if you will, are deemed to be not preventable. So I think that all the work, the front end work, both through the study, the research, the demonstration program, and the engagement with industry, has borne itself out in the success of the program.
You kind of touched on something that I was going to ask you next. You're talking about the numbers there. I mean, does this program work? Has it been a good program?
I think from everyone's perspective, yes. Again, a large number, and we see some of the data here. Thank you, Sean, for sharing that. We talked about the 97% factor. Now, I think one thing to note here, if you look at the top left chart there, an important factor here, of the overall determinations, 60% are not preventable, but 40% are ineligible. And that's an important factor. That 97% I talked about was 97% of the 60%, if you will. You can see that only 1% are deemed to be preventable, but 40% of the determinations are deemed ineligible. And there's various reasons for that. They don't meet one of the classifications of the crash types. And probably the thing we wanted to make sure you all are aware of, a big part of that 40% are carriers that are not responsive. So if an investigator is reviewing the data, your submission, and they're reaching back out to you to ask for more information or more documentation, a good number of that 40% are those who didn't respond to those requests, which is a travesty. So if you are gonna make the effort to submit the data in the first place, make sure you follow through, because almost every single time you're going to get it deemed to be not preventable. So that's an important part.
Thanks very much. I just realized I got ahead of myself, and you guys have got a little bit more information here to present. I kind of jumped the gun in asking for the audience questions, so we will get to those, but I want to get back to the last of your presentation.
No, I think from our, we know we're getting short on time, Evan, a little bit. So I think this covers the major elements that we wanted to talk about on the data side. I think, Sean, you might want to mention
Yeah, I'd love to jump into this slide just for a little bit, if you don't mind. This is some
Sure.
data that we've been crunching here at Scopelitis Transportation Consulting to answer just that question you asked, Evan. Does the program work, and how can carriers use it to best position themselves for success? And so what I've done here is I've taken the top 10 crashes or crash scenarios in the program and sort of laid them on a chart from most used to least used, at least in the top 10 scenario, but then tried to look at it a little bit closer as far as what percentage of all crashes that are submitted are eligible, and what's your overall success rate. So just some highlights here. Struck in rear is easily the most contested crash type, and also one of the most successful. 78% of all crashes submitted in this category are deemed eligible for review. That's the second highest after animal crashes, with an overall success rate of 76%. If you consider just the eligible, we're looking at 96% of all those crashes are not preventable. Now, when you move to different categories, however, the story changes quite a bit, right? So struck inside at rear, Steve talked about the 7 o'clock and the the 5 o'clock and the 7 o'clock position for struck inside at rear. And they're very strict about that. And so if it's not at the 5 and 7, it's not going to be eligible. And only 46% of all crashes submitted to this category are found to be eligible. When you do meet the criteria, 96% ultimately are determined to be not preventable. But then looky here again at this fail to stop scenario, right? 73% of all crashes in the fail to stop, and this is fail to stop at a traffic control device, are ultimately determined to be eligible, and 97% of those are determined to be not preventable. So that's great, right? But if we're talking about fail to slow in traffic, so there was no traffic control device, but traffic had slowed, boy, the picture changes quite a bit, right? That particular situation sort of flips right on its head, where most of the crashes are deemed to be ineligible, right? So there's a lot of variation, and if we look at that variation, we can determine, which are more successful than others, and how to submit our best, give ourselves the best chance of success. The last one I'll highlight before moving on here, as we run out of time, is this rare and unusual. This did that really just happen sort of crash scenario that Steve talked about. This has become a catch-all for carriers, right? They look at their crash scenarios and determine, well, this one was clearly not preventable based on the video evidence or whatever that I have, so I'll submit it to this rare and unusual. But sadly, only 15% of all crashes submitted in this category are ultimately eligible at all. And the overall success rate is only 12% of all crashes submitted. So it's a pretty high bar to get this crash scenario to be determined not preventable. Of those that are eligible, only 82% ultimately are determined to be not preventable anyway. And so that's the lowest of all the groups. And that gets, again, to Steve's point about making sure that we respond, giving ourselves the best chance to succeed. And then, ultimately, of all the unsuccessful RDRs, we see 3% are determined to be preventable. And so if I have a takeaway for any carriers on the call, the last thing that you want to happen is to submit a crash that ultimately is determined to be preventable. Because while a non-preventable crash is removed from the calculation of the CSA score and is noted on your profile as not preventable, the preventable crash stays on your profile and is marked as preventable, which in my mind at least is the worst case scenario. So short answer to your question, Evan, yes, I think the program is wildly successful. Yes, I think we can improve, and if carriers pay close attention to the crash scenarios, I think they'll find that they have a better success rate.
Okay. I want to get to some listener audience questions real quick. Thank you again. One of them is someone's wanting to know that can preventability programs help make a fleet safer beyond incentivizing good behavior or penalizing bad behavior?
Yeah, I'll take a stab at that, and then Steve, you can hop in. But I mean, I think that's essentially why carriers use those programs, and some of these programs are being replaced in some way with cameras, right? Because a huge benefit of these preventability programs is coaching and is thorough investigation of crash scenarios, so you understand sort of root cause and you can focus driver behaviors on those types of things. So you have a not preventable crash, you determine the final causation, you go to the driver and you say, hey, these are the things we need to improve on. And I think that's where a lot of your benefit comes from ultimately. That's why carriers adopt these programs.
Yeah, I think the thing that I'll add to that is a couple things. It gives you the results are good data to evaluate where you're having your problems, all right? Where, are there particular geographical locations, particular lanes where you're having, higher propensity of crashes. It allows you to peer into things a little bit more and what may be contributing to those crashes. And also you can kind of weigh that against your policies. How are our policies working out with respect to this, and maybe tweak or modify your policies to address, how the results of the program is working. And also at the end of the day, it's about culture and a commitment to safety, and and it sends a good message to your drivers. We care about this. It's important to us, and we're going to go to bat for you in those situations where it's an issue. So I think it benefits on a number of fronts. Beyond just kind of the one-time situation, it helps sustain that focus on safety.
One last question regarding internal programs. Are there situations that are almost always considered where a crash is considered non-preventable?
Yeah, I guess I could hop in, Steve, unless you want to hop in first. I mean, I think there are very typical scenarios where most often those are not preventable, but I've worked with carriers with these types of programs before, and truthfully, sometimes it breaks your heart because you look at the job that a truck driver has to do, and all of the many ways that hindsight can show, well, you could have anticipated X, Y, or Z, which ultimately results in a preventable determination, which is really challenging. So it is hard to get not preventables. There are some scenarios that lend themselves to those, like for instance, if your truck is properly parked, that's parked in a parking spot where they belong. But even those scenarios have exceptions, right? If your truck is parked on the side of the road because it's broke down and you didn't put your hazards out in time or in the appropriate location, well, then you may have that may ultimately be preventable if the driver's in violation of a company policy. So I think there are some common scenarios that are typically not preventable, but there's always exceptions.
Well, I think the only thing I'll add is in many cases, many situations, it's a case-by-case basis because there's also other contributing factors. And I think having the right mindset going into these programs and not having it be punitive in nature. And Sean mentioned this, coaching, using it as a tool to help improve driver behavior and performance. I think is the proper mindset on the carrier internal programs, because you're trying to improve the driver. Yeah, yes, there are very rare situations that not preventable is designated, but it's an opportunity to improve, and that impacts on the entire company.
Okay, some great information from both of you. If you'll see on screen, you can get a hold of Sean or Steve either by email or phone. Sean, we left a number out there. What is that area code? We got 20. What's that third digit?
That's a 202.
Okay,
Washington,
202.
D.C. Yes, sir.
Okay, and they're their phone numbers and emails. So that is all the time we have for the webinar. For the audience, please do not forget to fill out the short survey, which you will see in just a moment. Also, don't forget to visit the PrePass website at prepass.com, where you can read blogs and white papers that can help your operation and listen to podcasts as well on current topics in the trucking industry. I'm Evan Lockridge for Sean Garney, Steve Keppler, and everyone at PrePass. Thank you for attending today's webinar.
Thanks, Evan. Thanks,
Thanks
PrePass.
very much. Appreciate the opportunity.